Hello, everyone. Thank you very much for joining us for this joint evidence dialogues / dissect project conversation. I'm Yvonne McDermott Rees. I'm a law professor at Swansea University in the UK, and I'm a member of a project called Evidence Dialogues, which is an interdisciplinary project that seeks to discuss in an interdisciplinary context issues relating to our understanding of evidence and the evaluation of evidence. And as part of that, we do a conversations with series. So we're absolutely delighted to have Professor Marie-Bénédicte Dembour from the University of Ghent as our guest today. Marie, over to you.
Well, so yes, you've already given my name. You've already said I was from Ghent. I can add that I am the PI of an ERC research project, which is called DISSECT, Evidence in International Human Rights Adjudication. And it's a pleasure to have been invited by Yvonne to talk to evidence dialogues. And of course, then I said, yes, of course, I'm very happy to do it. And let's make it a joint event. And so this is also, as you said, an event which is, in a sense, hosted by DISSECT.
Fabulous. So, Marie, tell us a little bit about your journey, I suppose, to evidence studies. I know that your background is in anthropology. How did you come to become interested in evidence?
Okay, yeah, I mean, I have a background in anthropology. I also, in a sense, have a background in law. I studied law as an undergraduate. That was 5 years at the Université Libre de Bruxelles. And then indeed, I studied anthropology at Oxford, did my master and then did my PhD. But then since then, I've always been located in a law department or school. So yeah, and I became in a sense, you know, where life took me was to study human rights, especially the European Court of Human Rights. And why evidence? Well, partly by chance, I would say, and maybe partly also because it was meant to happen. So by chance is because I was looking for an interesting topic of research which may have led to an ERC grant, and that has to be frontier of knowledge, and it has to be original, and it cannot have been done before. And I had been wondering, what could I propose to research? And then suddenly one day, actually taking my shower, and not because I was thinking about what grant to have at the moment, but I had this idea, oh, I should do it on evidence. And as soon as I got that idea, I thought this is a winner. It's a winner for a number of reasons, being that it's very interesting. I think we agree on this, at least in this panel. We all find it absolutely fascinating. So it's very interesting, it's very important, and it's not done very much before. So that's the chance element. Suddenly it came to my mind. I don't know which connections were being made in my brain at the moment, but at the same time, I said, you know, maybe it was meant to happen, because even though I had not consciously thought about evidence, I realize now, retrospectively almost, that I had always paid attention to evidence. And so I happened to be reading the very first article I wrote on the European Court of Human Rights. It was on Article 9, freedom of religion. And, you know, so completely fresh from anthropology, where I was not studying law or human rights. And evidence is already there. And if you look at my last book, When Humans Become Migrants, Study of the European Court of Human Rights with an Inter-American Counterpoint, there is quite a bit of evidence. So I think my way of approaching the study of law is kind of led me to be interested in these questions. And it's not, I think it's not a coincidence that, in a sense, today, you know, we are in the Zoom room with William Twining, whom, of course, has been the authority in the UK about putting the law of evidence on the map, and really, yeah, we very much leading the way. And in fact, it so happens that William was, you know, the one person who decided he really wanted to have my monograph, nothing to do with evidence, but called Who Believes in Human Rights, in his series for Cambridge University Press. But because I think that William's amazing interest in looking at law in a comparative way, in a global setting, also looking at what's happening, you know, if we use the label as a legal realist, but also as a theorist about what does law in the world, kind of, it's not a coincidence that William was also interested in evidence, that when he looked for a topic, because I listened to your really interesting evidence dialogue with William, where he says, well, I had to find a topic which I could Warwickize, and he chose evidence. No wonder. My other mentor, Jack van der Linden in Belgium, who was also an amazing mind interested in thinking about law in a, you know, like in history and in the world, and looking at African law, and looking at the developments, the technological developments, and at education, and at this and at that. One of his first major work was to do a major congress of the Société Jean Bodin pour l'histoire des institutions. So gathering people from all over the world to try to have really a comprehensive examination of what la preuve, so evidence. And so, you know, it just fits. I think it fits the mind of lawyers who are not interested in law, in a sense, just as law, but as law, you know, William might say in context, I would say law in society. And so I think it fitted very, very well.
It's really interesting. And that gathering that your mentor Jack put together, was that just lawyers from different legal systems, or was this all sorts of people from
I don't think it would have been interdisciplinary as such. There might have been, I mean, it would have been, again, law in context. And I don't know if we say that law in law in context is interdisciplinary, of course, but it also, in a sense, is using other disciplines to have a certain certain enlightenment about law, but it remains law orientated, and there is nothing wrong with that. You know, lawyers look at lawyers, biologists look at biology. So, but what I mean is that I think in Société Jean Bodin, you might have had historians of law, or you might have had a few anthropologists of law, but it does, I suppose, complete interdisciplinarity for me would be that you even go at one level above that, and that law does not necessarily need to be the unit of examination. You look at something even more cross-thematic, if you like.
Yeah, that's actually one of the things we're hoping to do in evidence dialogues, is transcend those, you know, hard versus soft science, social sciences versus STEM, to look at, like, are there shared understandings about what constitutes good evidence, about how to approach and evaluate and weigh up, you know, mixed bodies of evidence. Do do you think there's any sort of shared concepts, let's say, between anthropology, where the research methods are quite different, and law, and between other disciplines? Is the
Okay, I will only talk about anthropology if you allow me, because if I need to talk about others,
we'll be here.
I don't know anything about, that's going to take us too far. But I think what strikes me, anthropology would not necessarily have as its main question what is good evidence. The main question, I think, would be, how is evidence dealt with and approached in this particular social setting, which is a slightly different question. So I think the driving force is not going to be normative, although it might get to some normative, but it won't be, the question won't be, what is good evidence? The question will more be, what is being considered evidence? Why is that so? What are the consequences? Who is part of that? What does it tell us about power, about cultural understanding, meaning? So I think the starting point is slightly different, which probably means also that the end point would be slightly different.
Yeah. And what's seen as credible or reliable, I suppose, if you don't have that, and I'm thinking about this a lot because, as I mentioned just before this call, just yesterday, the International Criminal Court had a judgment of a former child soldier from Uganda who was captured as a child by the Lord's Redemption Army and recruited as a child soldier, and then sort of rose up the ranks and committed atrocities in that context. But within that, there was a lot of stuff about witchcraft and about the powerful people, and he put a spell on me, and just the way that the court dismisses some of these things, I think is really interesting from an anthropological perspective, isn't it?
Yeah, and who can talk, who has authority. Of course, we have that in law as well. I see that in the human rights jurisprudence. An intergovernmental body report will have more weight than a report which is being written, I don't know which example I would take, but I think that there is a gradation about authority, and the authority hierarchy we cannot assume that what we are being used to in our let's call either the European world or the Western world or whatever is going to be reproduced in the same way in other societies. So who can speak the truth is not always approached in the same way. And you could say, but if you are objective, it must be this or that, but actually no, because they think they are objective as well. So what is objective is a big question.
That's really interesting. So kind of picking up on that, I know that DISSECT really interrogates this idea, the meaning of truth. And I know you had one of these other events earlier this year that looked at the notion of judicial truth. So, how is that different to, I don't know what we might call the real truth, or like broader truth, and why does it matter to look at this in the context of international human rights adjudication?
Okay. All right. Well, having been trained as a lawyer, my first reaction would be, okay, judicial truth is what the highest court has said, and that has to be, in a sense, accepted. At least in the legal world, it's accepted. It's res judicata. So that's the autorité de la chose jugée, and that's not to be brought into question, at least in a legal forum. Whether that judicial truths correspond to the social truth or to the real truth or to the objective truth is another question. You would expect that the judges will want to have the judicial truth being corresponding and in a sense having a perfect overlap with these other truths that I'm talking about. But it does not always happen. And what is interesting, I mean, in DISSECT, one of the things that we have been discussing now for a while is that not all human rights courts would think, or would say, not all judges in the courts would say that evidence is important because then they can attain the truth. That is not necessarily the first aim, because many judges, for example, in the European Court of Human Rights, will have said to Anne, who is our PhD researcher working on the European Court of Human Rights, that what they need to do as a judge at the European Court of Human Rights is to decide whether there has been a violation of the convention. And so they don't need to know all that happened. They don't need to have a full history of an event. They don't need to get everything, in a sense, right. What they need to get is, was there a violation of the convention? And so it's much more specific. And, you know, if we go to a different system, the Inter-American Court, by contrast, has actually said that even though it's not written in the convention, the right to truth, it now considers as a human right. So it's also, it's going in more in the direction of, you know, victims deserve to have the truth being acknowledged. And so the Inter-American Court is much more interested and wanting to manage to produce accounts of events which would be true, in also the sense of true, not just in a judicial sense, but corresponding to what the people outside the court would recognize as being true. But of course, it's, you know, it is very, very difficult to achieve. And the courts, the human rights courts they don't have any police to investigate. They always have, well, they mostly always have to rely on other parties, the other parties being mostly the applicant, the defendant state, and then if they are lucky, or if they wish, it depends. The Inter-American Court is very happy to get third-party interventions and to hear witnesses and experts, and will always have a public hearing for every case, while the European Court of Human Rights is not, that doesn't want that, because they say, well, you know, we're not there to establish the truth anyway of all that happened. We're only there to decide whether there is a violation. Overall, or, you know, in the very great majority of cases, with very few exceptions, we think we can do that without hearing witnesses. Well, we may have third-party interventions, but then, you know, you need to ask for authorization, and then you know, you need to tell us what you're going to talk about, and it cannot be on the facts. And so it's a different orientation altogether.
I wonder what's motivated this different orientation. Is it that the European Court is an older institution and as such is a bit sort of traditional in its approach, whereas the Inter-American Court is, in all sorts of ways, is quite like dynamic and open to trying different things, and often to quite, you know, really progressive interpretations of the law? Or is it something to do with efficiency, that the European Court of Human Rights is under so much pressure to be efficient and to get through this massive backlog of cases? Perhaps that's also true for the Inter-American Court, I don't know. Or is it to do with the background of the judges, that maybe in the European Court you have more judges, actually not that many when you think about the different legal systems, but that hail from the common law adversarial tradition where the role of the judge is more of a sort of an umpire?
I think it's everything that you have been mentioning. There is never only one
answer. Yeah.
Well, sometimes I suppose there can be only one cause, but very often there will be a number of circumstances which come together to explain a particular tendency. To begin with, if we think of the European system started thinking it wouldn't need to discuss evidence anyway, because it was there as a safeguard in case, in the unfortunate event that a state might do a little bit something wrong, but it was hoped it would not. And then you would have a citizen being able to alert the international system to the fact that the rule of law and democracy and human rights were in danger. But the idea was that there wouldn't be any case anyway. And if there was a case, in a sense, one would know the facts, and one would, the judges would decide on that. Of course, this is not what happened in practice. And so right from the start, there were very fact-heavy cases in the context of conflict. We had the Greek cases involving the British reaction to what was happening in Cyprus, which was still a colony, which was kind of insurrecting itself. So it was very immediately, it was messy, if you like. But the European Court of Human Rights, nonetheless, right from the start, was really trying to avoid to avoid states, especially or including the United Kingdom, to give them an excuse to get out of the system. So there was a wish to appease the states, and you can see that in the Ireland versus United Kingdom case, which is a case from the 1970s, which also had to do with the conflict in Northern Ireland. And it was to do with the 5 techniques of sensory deprivation to which the IRA detainees were subjected by the British authorities. And Amnesty International had said it was torture. The European Commission of Human Rights thought it was torture. And then the European Court of Human Rights, when it decided the case, basically said, we're going to adopt the standard of beyond reasonable doubt, which of course was the standard that the United Kingdom had wanted the ECHR system to adopt. The Commission thought that torture had been proven beyond reasonable doubt, but the European Court disagreed and thought there was not enough. And I think you can see there that there is always, right from the start, there will be this tendency in the European system of adopting norms and taking judgments which are very cautious in terms of not stepping too much on the states. In the Inter-American system, right from the start, you have just the opposite. And so the first case before the Inter-American Court is called Velázquez-Rodriguez versus Honduras, and it's about forced disappearance by the state. And forced disappearance is by nature an action where the state is going to make the person disappear, but also evidence about the disappearance disappear. So there was no direct evidence. So if the Inter-American Court had remained with the idea, well, the burden of proof is on the applicant, and the applicant must prove beyond reasonable doubt that their relative has been disappeared, it would never have worked. And so the Inter-American Court, right from the start, says, okay, here we have a pattern of disappearance, which has been evidenced not by the applicant, but by international organizations. There are reports. We know it's been happening. The applicant have shown that their relative had been abducted, and there are witnesses about this, and it fits the pattern. And so we accept that the disappearance has taken place, and there have been a violation of a number of provisions of the convention. And that puts immediately the two systems in very, very different tracks in terms of the way they're going to approach evidence. And that remains to this day.
Yeah, I think you see it in, I was reading just before this, a blog post you wrote about a case, I think it's PH and Slovakia. And there you said the European Court took this position, basically accepted the state's narrative that the applicant had jumped, I think it was 7.7 meters from a window, trying to escape from the police. And in your, well, maybe you want to talk a bit more about it, but in your post you point out the sort of illogical nature of this, and again how the burden of proof effectively, you know, was placed on the applicant, whereas
yeah, I mean, I am glad that you've picked on that and that you agree with me. Then you know, this is the case of a young Roma woman who is taken to the police station having been caught stealing in a shopping mall. And so she's taken to the station, and then, you know, it's decided that what she had done was not so bad, so that it does not warrant her to be kept in remand detention. And so she's going to be freed. But before she's freed, she asks to go to the bathroom. And she goes to the bathroom. She's escorted by a police officer. And he turns his back on her. That's the version of the state and accepted by the European Court of Human Rights. He turns his back on her and she jumps. She jumps from a window to escape, even though she's about to be released. And the window is on the second floor. So it's 7.7 meters high, as you say. And I'm like, and the court accepts what the state is saying. Well, you know, nothing we could do. I mean, she just wanted to escape. And I'm like, who escapes from a window of that height? Who believes that they will jump and then they will go further? I mean, what happens to this young woman is that she falls. And in a sense, she's very lucky because instead of dying, she's in a coma for a month. But to me, for the court to accept that version of events by the state is against all common sense and all logic. So, you know, in my blog post, I say that I think it's absurd. Mm-hmm. Some people have told me, don't use the word absurd. It's too strong. And I'm like, but what else is it? I mean, you know, I mean, of course, in some circumstances, you might jump from a 7.7 meter high window. You know, if there is a fire and you think you're going to die, yes, of course, you may prefer to jump and take your chance. But in normal circumstances, if there is not something threatening you, you're not going to try to escape by jumping from a window. And to me, I just don't understand it. I don't understand that the European Court of Human Rights accepts that version of events. The more so that normally there is a well-established principle that if someone enters detention in good health and then leaves in bad health, and there is no reasonable explanation for that, the burden of proof shifts on the state to explain what happens. In this case, the court is satisfied that, it doesn't talk about shifting the burden of proof, but it's clear that it's satisfied by the explanation of the state, which is she jumped out of her own volition.
Yeah. Again, I think it ties in with these ideas of epistemic injustice and stuff that you touched on earlier, where I think in that case, the claimant herself didn't remember what happened. So there's no counter narrative to put to it, which maybe was which maybe convinced the court more. But yeah, there seems to be, as you say in your blog post, which I'd recommend anyone to read, we can share the link on our Evidence Dialogues page, a question about, if you're asserting something, there's a principle that you should prove it, but it was just a bare assertion that seemed to be accepted. Marie, I feel like we could talk all day, but I'm also conscious that we have an audience here. So I wonder if we have any questions from anyone in the audience. William, I can see you're unmuted. William Twining.
This is very interesting. I want really to push things in the direction of our evidence dialogues concern with not being hedged in too much by law as a way of looking at things and so on. And so one of the first questions I would have about your project is, when you're focusing on adjudication, are you only focusing on adjudication?
Okay, that's the end of your question? Yes. I take it from here. We are, I think overall we only look at adjudication, but of course, what happens in adjudication also is influenced by what happens immediately before adjudication. So I don't know what you mean by adjudication, but for example, we have one member of the team, Nina Koloratnik, who is looking at how evidence is being, which is being evaluated, but also before that collected and submitted in cases involving indigenous communities basically in Latin America before the Inter-American Court of Human Rights. And so she is also she's been very much interested in trying to follow even how the legal team then approaches what we could call the story and the reality and the truth of these indigenous communities who are part of legal cases. In a pending case, that it's even an indigenous community who is actually not in contact with the Western world. So they're in the Amazon, and they're not in contact. They don't even know that the case is being brought on their behalf. And so it really raises very difficult questions about, what do you know? How do you know it? How do you put it across And these are questions which interest her, obviously looking at what's happening in that case. But as I said, once you really look at what's happening in the case, then it brings into question what happened before it was submitted before the court.
Great. Any other questions?
I would be very happy to jump in. Thank you very much. I would be extremely interested to hear from you, Yvonne, how Marie's very accurate accounts from the regional human rights courts compare with or sit with the practice of the International Criminal Court and other criminal tribunals, and their practice of gathering, admitting, and evaluating evidence.
Oh, thank you. I heard a lot of things that really struck me as very familiar. So this idea of, some judges being quite open to the idea that we're establishing the truth, we're doing this for the victims, we're establishing an historical record, versus others really taking the position that we're here to conduct a narrow factual inquiry into whether this person is guilty beyond reasonable doubt. And so I think that was something that's very much familiar in the international criminal context as well, this struggle between what is the proper role of the judge, because in the International Criminal Court statute, it actually says they have a role in searching for the truth, but then this sort of judicially mediated notion of the truth and limiting themselves to a role of umpire rather than actively truth-seeking function. And the other thing that was really familiar to me was this idea of inconsistency between systems. So I'm trying to write a book on as William knows, on proving international crimes, basically on international criminal evidence. And not only is there inconsistency between different tribunals and what they do, but also between different chambers within the same tribunal take very different approaches. So it's difficult, right, to talk about a system as a developed system, coherent system of law, when you have so much inconsistency and flexibility that's given to the judges to decide what to do. So I think lots of similarities between the two bodies of law. Would you agree, Marie?
Yeah, absolutely. I mean, yeah.
Marie, maybe to close off, to end this conversation, I wondered what's next. Where do you hope to be by the end of the DISSECT project in terms of the big findings? And where do you think this work will take you next, or are you just waiting and seeing?
I mean, one thing which strikes me is, I suppose every project I have started, there is something which pushes you towards that project. And I suppose in my case, there is always a little bit of, oof, how come they do that? So there is always a little bit of, in a sense, not being quite happy with what I see. And I suppose when I started this project, I knew from my book, When Humans Become Migrants, that I was not happy with the case law of the European Court of Human Rights on migrants, and that it was not all because of evidence, but that evidence had a role to play. So that on the one hand, applicants were being asked to bring evidence which they possibly cannot do, or they were not found credible, or that the versions of the state would be accepted. I think one of the things which has already happened for me, and that is probably a common trend in my scholarship, is that I start looking at it, and that in a sense it's worse than what I expected. And with the European Court of Human Rights, I would say what is worse is that I now get the feeling that sometimes the court actually dismisses facts which I would have thought were well established, and I'm really puzzled by that. I mean, in a sense, the example you gave of PH versus Slovakia is a little bit like that, because even though it was not established that the applicant did not jump from that window, so that it seems to me in one way or another, maybe not physically, but even just by signals or whatever happened, but that a jump seems to me impossible to contemplate. A voluntary jump seems to me impossible to contemplate. So I cannot believe that there was an attempt to escape on her part, or at least to escape just from the police station. Maybe she was escaping something, but then what was it that she was escaping? And this denial of facts by the court, I find really, really, really troubling. I mean, another example would be the case NT and DT versus Spain, where where the applicant, supported by a number of organizations, say there is no legal route for asylum seekers to go from Northern Africa to Spain. And so, they try to go into Melilla, and then they push back from Melilla, and the court dismisses and says, no, there were possible legal routes. And I'm like, come on. I mean, you are being told from a number of different sources that there are none, and then you say, no, it would have been possible. How can you say that? And I am really troubled, and I've said, well, it's worse than what I expected, because I think at the basis of the rule of law needs to be at least good faith. At least you do not manipulate the basis of the facts. Maybe you interpret them, but you do not ignore evidence which has been submitted, or you do not declare it to be untrue if you don't have evidence to say that it was false. And so in that sense, when you ask me where it's going, I can say I am really troubled about this whole reflection about truth within justice. I mean, obviously, at another level, I started to do a comparison between the European and the Inter-American Court in my book, When Humans Become Migrants. I continue to be interested in that. I think it's very, very important that we bring the African Court in, which also has very interesting jurisprudence. And so I think understanding what is happening, that's the first thing that as an anthropologist you would want to do, is just what is happening there. So I think making sense of the different rules and practices, that's the number one goal. Having this reflection on truth and the relationship to human rights, but beyond that, democracy, and where are we going in our society is the second.
A bit of a maybe slightly off the wall question, but I wonder, has anyone ever thought about doing any like Wigmorian analysis of the inferential steps that the European Court or any other courts of this nature has taken, because I was you've seen William's book, haven't you, Analysis of Evidence, that sets out this argumentation mapping schema that that can be used, and within that there's scope to include generalizations. And so some of the things that you mentioned there, I thought, oh, I could see where that would fit in a Wigmorian analysis as like a generalization.
Yeah, I would have loved to hire a philosopher or theorist, I don't know how we call them, but someone who would really look at the validity of statements and the validity of reasoning about evidence. In a sense, it was there in my mind when I put the project together, when I wrote the application. Nobody applied for doing that. So at the moment, yes, we don't have it, and I think it's a gap. But then there will be many gaps. You can never fill all the gaps. But I think it would be great to have this kind of analysis.
So interesting. Marie, thank you so much for taking the time to speak with us today. Really appreciate it, and yes, we'll continue to be in touch and be in dialogue between our two projects. So thank you.
Thanks to you for inviting me. And yes, as you said, we'll keep in touch, definitely.